Hello. So my name's James Arthur Sharpe, and I have with me here Helen Nettleship, and we're going to be doing this webinar this afternoon on threshold documents. Essentially, what's going to happen is I'm first going to do a couple of introductory remarks, and then we're going to go into the webinar proper. It's got 3 sections. I'm going to lead on the first 2 sections, which is about Section 31 of the Children Act 1989, and also about the case of REA, which is very significant in this area. And then Helen's going to take over and deal with drafting of threshold documents. So first, 2 introductory remarks. First, the purpose of this seminar. This is entry-level stuff, but we hope that more experienced practitioners will benefit as well, because it always helps to be reminded of the basics. And the second thing is just an observation about threshold. Threshold is so often a contentious issue within proceedings, but if you leave this webinar with just one thing in your mind, it's that most of the time, it really shouldn't be a significant issue. Ultimately, when we think about threshold, what is it? Once it's been established, that provides jurisdiction for the court, and the court can move on to the more important questions, and that tends to be in relation to the welfare of any child. Most of the times, it should be agreed. If it can't be agreed, well, that may be because threshold is of such significance that it goes to the very heart of the case. That's when you have, for example, a fact-finding hearing. But generally, threshold should not be an issue. And so I would encourage anyone who's watching this, whether you're for local authorities or for parents, try and agree threshold as early as you can. So turning now to the first part, which is going to be on Section 31 of the Children Act, I think it's always helpful to go back to the statute just so we can remind ourselves what it is. You'll see it set out there. I'm not going to read it out for you because you can read it in your own time. But essentially what we can see is when we're dealing with threshold, we just need to go back to Section 31(2) for the definition. I'm going to note 5 things in a moment arising from this definition in just a moment. But the other crucial part of Section 31 is Section 31(9). The reason why that's significant is, as you'll see, it also it gives some very important definitions, in particular, the definition of harm and what that means. And as you can see, it relates also to matters of development and ill treatment. So what should we note that arises from Section 31 of the Children Act? First of all, we have that the harm suffered must be in the present or the future. The past is simply not enough. And that makes absolute sense, because when we go back to Section 31(2), you'll see that the way in which it's phrased is that the child concerned is suffering or is likely to suffer significant harm. So if the child has suffered harm, but there's no evidence of currently suffering harm, and there's no reason to believe that there will be harm in the future, that's just not enough. Often, of course, we always use past events in order to demonstrate either present circumstances or future circumstances. But the crucial thing in terms of drafting is it must be drafted in terms of the harm, it must be drafted in the present or the future tense. Secondly, that the harm must be significant. Now, there's no clear definition of what significant actually means, but there is help in the case law, and I've just given 2 cases here. The first is, as the Humbleside CC and B, it must be considerable, noteworthy, or important. And the other case is the case of REMA. It is significant enough to justify the intervention of the state and disturb the autonomy of the parents to bring up their children by themselves in the way they choose. And 2 other points to raise there. It can be cumulative as well. So sometimes you may have arguments in court about saying, well, this is harmful, but it's not significant harm. This is harmful, but it's not significant harm. This is harmful, but it's not significant harm. The cumulative effect of it can nonetheless be significant. And the finding is a finding of fact on the balance of probabilities. So it's a finding of the court in that sense. Thirdly, likely to suffer it must be a real possibility of suffering that harm. Fourthly, the relevant date that we have to take into account is when protective measures were first initiated. Normally, that will be the issuing of care proceedings. They can also be when police protection was exercised or when a child was accommodated under Section 20 of the Children Act. Even though the relevant date is what is significant in terms of establishing threshold, though, we do have the case of Reed G, which makes very clear that events which happen after the relevant date can also be used in a threshold document because they provide evidence of, whether the child was suffering at the relevant date significant harm, or whether the child is likely to suffer significant harm in the future. And fifthly and finally, in this section, we know that the significant harm must be attributable as defined by Section 31 2b. And just to remind you what that is, as we go further back, of course, it's the care given to the child, so normally by the parent, although it could be someone else like a special guardian, for example, or likely to be given to him if the order were not made, not being what it would be reasonable to expect a parent to give him, or the child's being beyond parental control. Now, in assessing that, of course, again, it's an objective test, and it can include acts of the parents as well as failures to protect, certainly within Section 31 2bi. In terms of BII, the child's being beyond parental control, normally that involves older children and not younger ones. And then finally, in this section, just because we have to remind ourselves of this as well, is interim threshold. That is Section 38. The crucial words are they reasonable grounds for believing. So those are the crucial things. We are looking again at Section 31(2), but reasonable grounds for believing that that test has been met. And the reason why I highlight it here is normally when you're drafting documents, just be really careful you've got the right test for the interim threshold document compared with the final threshold document. Okay. So those are the basics in terms of Section 31, but also Section 38 of the Children Act. So moving on then to the case of REA, that's a citation, as you'll see there. Just thinking about the case, first, the basic facts of the case are as follows. It involved a child who was 1 year old, who was born to a mother who was imprisoned for a number of offences, including, as you'll see, sexual offences. The father was putting himself forward, and he was the subject of a negative assessment. But crucially, what Sir James Mumby, when he was president of the Family Division, concluded was that the criticisms that had been made of the father didn't establish, or what essentially weren't linked to demonstrating that there was a likely risk of significant harm to the child in the future in the father's care. And just to expand on that briefly, some of the criticisms of the father were, for example, that he'd been a member of the English Defence League when he was younger, and essentially the social worker, one of the social workers I know, described him as being an immoral person, and he was also described as being an immature person. And essentially, what Sir James Mumby said is that, well, yeah, fine, okay, he may be a racist or he may be immature in some, but what you've got to demonstrate is that's linked to actually significant harm for the child. And he said, well, that linkage just wasn't made. That's the real crux of this case. And it's also important to to recognise that just because this is what the recitation of the case of Riel, the very famous case that we're all familiar with, that just because we may disagree with someone doesn't mean you start to make the linkage to significant harm. So that's the basics of basic facts of the case. But there are 3 paragraphs within this judgment which are really significant when it comes to dealing with threshold. The first is paragraph 9, and this relates to the issue of primary evidence. I'll read it out to you. So, if the local authority's case is challenged on some factual point, it must adduce proper evidence to establish what they seek to prove. Much material to be found in local authority case records or social work chronologies is hearsay, often second or third-hand hearsay. Hearsay evidence is, of course, admissible in family proceedings, but, and as the present case so vividly demonstrates, a local authority which are unwilling or unable to produce the witnesses who can speak of such matters firsthand may find themselves in great or indeed insuperable difficulties if a parent not merely puts the matter in issue, but goes into the witness box to deny it. Now, this is a crucial point which I know Helen's going to expand on later when she deals with drafting. But the point is we're looking at primary evidence. Now, that tends to be quite difficult at an interim stage because you haven't got all the evidence. It may be that in the bundle, all you've got is the social worker's statement, for example. And a lot of that, as Sir James Mumby notes in this paragraph, is likely to be hearsay evidence. Social worker may have some primary experience of the care, but the likelihood is that social worker. So the interim stage, we are likely to be relying on that sort of evidence, but certainly by a final threshold stage, we should have the primary evidence and we should be relying on that primary evidence. It's not enough to say, simply to rely on hearsay evidence in its entirety. The second point is a matter of pleading, and this is at paragraph 10 of that judgment. The schedule of findings in the present case contains, as we shall see, allegations in relation to the father that he appears to have lied or colluded, that various people have stated or reported things, and that there is an allegation. With all respect to counsel, this form of allegation, when one sees far too often in such documents, is wrong and should never be used. It confuses the crucial distinction, once upon a time, though no longer, spelt out in the rules of pleading and well understood, between an assertion of fact and the evidence needed to prove the assertion. What do the words, he appears to have lied, or X reports that he did Y mean? More important, where does it take one? The relevant allegation is not that he appears to have lied or X reports. The relevant allegation is, if there is evidence to support it, is surely that he lied or he did Y. Now, again, Helen's going to expand on this herself in her section of this webinar, but again, that's of crucial importance. Even now, I see this quite regularly in threshold documents that I've been provided, that he appears to have lied, or he appears to, there is an allegation that there was some shouting between the parents, or that there is domestic abuse in a particular relationship. It's reported. No, you've got to prove, in that case, that there actually is domestic abuse. That's what the pleading has to be, and the evidence then has to go along with it, such as police records or something like that. And the third paragraph of significance is paragraph 12. It goes over the page, so I'll read it all. But this is about linking assertions with the facts in the case. So the second fundamentally important point is the need to link the facts relied upon by the local authority with their case on threshold. The need to demonstrate why, as the local authority asserts, facts A plus B plus C justify the conclusion that the child has suffered or is at risk of suffering significant harm of types X, Y, or Z. Sometimes the linkage will be obvious, as where the facts proved established physical harm, but the linkage may be very much less obvious when the allegation is only that the child is at risk of suffering emotional harm, or, as in the present case, at risk of suffering neglect. In the present case, as we shall see, an important element of the local authority's case was that the father lacks honesty with professionals, minimises matters of importance, and is immature and lacks insight of issues of importance. Maybe. But how does this feed through into a conclusion that A is at risk of neglect? The conclusion does not follow naturally from the premise. The local authority's evidence and submissions must set out the argument and explain explicitly why it is said that, in the present case, the conclusion indeed follows from the facts. Here, as we shall see, the local authority conspicuously failed to do so. Now, this is perhaps the most crucial point of this case. It is about that linkage. And just to break it down, at the beginning of this paragraph, so if I just go back up, for example, we can see this point about physical harm. Well, physical harm tends to be something that's pretty obvious. Got a child who's got a broken bone or something like that, we can probably quite easily establish what the fact is that needs to be proved, as such as, as part of a non-accidental injury and the harm that's been suffered. In this case of Rie, the local authority was alleging neglect, but it's very difficult to see why, for example, just saying that the father isn't honest with professionals, why does that lead to neglect? This point about honesty is actually quite an important one, because very often I do see it pleaded within threshold documents. And I personally question why it should be there. Because the issue about dishonesty is it goes more to welfare than to threshold. Because if you're being dishonest about, for example, whether there is domestic abuse within your relationship or whether you're taking drugs or illegal drugs, the point is, the threshold point is the domestic abuse and the drug use. It's not about being dishonest about it. Parents can be dishonest about a myriad of things. It's not going to lead to significant harm. And I think, and that's crucially illustrated there. So those are the key paragraphs, I say, coming out of the case of Rie. I would encourage you to have a read of that section again. As I say, the section which actually deals with the threshold point is quite early on in the judgment. It is otherwise a very long judgment, which is very critical of the local authority, so you may not want to read all of it, but certainly those paragraphs do reward rereading. Anyway, that brings me to the end of the case of Rie. So I'm going to hand over now to Helen, who's going to deal with drafting.
Yes, I've got.
Yeah.
Yes. So first of all, drafting a threshold should be, I think, an enjoyable job for a lawyer to do, because it's an opportunity to really hone your skills, not just in drafting, but really thinking about what your case is, what you're trying to prove, what matters, what doesn't matter. It's difficult. Most of the time, it's difficult. Within a case, you're going to be drafting the interim threshold at the beginning of the case, and oftentimes a final threshold, which may be very similar to the interim threshold document, or may have moved substantially. And the difficult thing for a local authority solicitor right at the beginning, when you're drafting the interim threshold, is you won't have all the evidence. You're relying on what the social worker has provided in her statement, usually. And there may be some other documents that are key documents that are available to you, but you probably won't have everything that you would like to have. And more often than not, you haven't got much time. It may well be that the local authority have decided to issue proceedings because something, an incident has happened and they need to issue fast. It's less problematic if there was a mother who was pregnant and they know they're going to issue as soon as the child is born, and that work can be done in advance. But oftentimes it is highly pressured and you just don't have the time to draft it in the way that you want to do. But your interim threshold does need to cover the very basic information about why you are proceeding, what has happened. If it's a case, a long-term neglect case, but something has tipped it over the edge, which has made you want to bring proceedings, you really must set out what that precipitating event really is. You can always go back later on when you're dealing with the final evidence, final threshold, so that you can fill in the gaps of a bit more of the history of the case when you know about it. Certainly at the beginning, we're looking at the interim threshold, you won't have much. When you get to do your final threshold, you'll be looking at making sure you've got all your primary evidence that you need to prove things, whether there's police records, hospital records, expert assessment within the proceedings to demonstrate. It's an obvious point, but if you're alleging Class A drug use, you've got to have some hair swab testing, unless the mother or the father is admitting those things. Do not pursue allegations which you don't have evidence for, obviously. And you'll also need to reflect from when you draft at the interim stage to when you draft at the final stage about what you really can prove and what you aren't able to prove on the evidence you've got. Obviously, star point, cross-reference with evidence in the bundle. Every single criterion in your threshold should make a reference to the documents, and the page reference. So that's easily accessible. So this is from practice directions. Threshold statements mean a written outline by the legal representative of the local authority in the application form of the facts which the LA will seek to establish by evidence or concessions to satisfy the threshold criteria under section 31(2). James has taken you through that. It does need to be proportionate. You need to think about what are the key points, what really matters, what can you give away. The courts just don't have the time to deal with every single allegation you may wish to deal with. So if you put together a lengthy document with lots and lots of different allegations, not only will you be under pressure from those representing the parents to take a more proportionate view, most judges will do so also. So really think about your focus on the case. We'll do the next slide.
Yes, of course. Before I just move on, just one thing to make absolutely clear that 2 pages is what it says. It's actually in the practice direction. The threshold document should not be any more than 2 pages. I think both Helen and I have lots of examples from our own practices of getting threshold documents which are pages long and don't need to be.
And I think I'm guilty of drafting more than 2 pages long, which is why I glossed over that point. And the difficulty is if you're drafting, if you're dealing with, say you've got 7 children in a case on one threshold document, and there's a history of neglect, there's also drug issues, there's 1 or 2 of the children are beyond parental control, and there's domestic violence, there's different issues with different children. Some of the children have got psychological problems which you say are environmental. You may be struggling to fit that all on 2 pages. And you may feel it necessary to pursue those points because it's a big case, or indeed a big generational sex abuse type case. If it's a one issue case, one single non-accidental issue case, you should be able to do it within 2 paragraphs. So yes, short and concise as much as you can. Make it really clear. Focus on what the evidence you've got, the key issues. Every single criterion you allege should be able to say what is the harm that the children have suffered or at risk of suffering, whether it's neglect or significant emotional harm, and you need to explain why that is within that criterion. Use headers, avoid long narratives, of course. These are drafting tips which you will soon get out of the habit of doing, because if you do fall into using these, you will be very much criticised by your opponents in court and by the judge. So often a social worker will draft her evidence and saying, oh, the mother told me this, or the mother said this happened to her, or there was a police report and the neighbour said they saw this happened. And because you're working under pressure, the initial draft of the threshold document repeats some of that language. It's been reported that, or recorded that, or so-and-so said this. That's simply not okay. If you are alleging, you're alleging that the father hit the mother on a particular date. You're not alleging that the mother said that those things happened. You're alleging that they did happen. So make sure that's very clear. So the next example we've got here is in relation to drug use. Again, your allegation is that the parent is a class A heroin or cannabis or cocaine user, and because of that, it has impaired her ability to provide consistent care to her children, or you will have examples of when their care has been completely neglected. And then you will cross-reference to the evidence you've got about drug use, which is probably going to be a hairstyle test. The most important thing, I think, is proportionality. And so a case which is more straightforward, that may well be simply about the volatile or violent relationship between the mother and the father, of which the children have been exposed to. You can cut your cloth accordingly. So you may find it easier to just say there's been a history, and you're giving a few examples of which, when you look at the police evidence, you've got clear evidence of these things being admitted by the parents, perhaps a conviction or a witness, or indeed they're the things that the parents have actually admitted. And you may take a view, well, actually the parents have admitted one or two of these things. That's enough for my threshold. I don't need to go any further, because you're really then moving on to look at the welfare stage. But you have to take care of that, because if you're trying to establish that it is a relationship which has been clouded in domestic abuse for years and years and years and years, and is likely to continue in the same vein, if the parents have only made admissions on one or two things that happened 5 years ago, that's not really going to help you when you come to the welfare stage of things. Again, oftentimes you'll have a case where you've drafted the initial threshold, and it may be imperfect, it may be okay, and the parents have made a few concessions. And as things progress through the case, really the outcome you're looking for is a supervision order. The parents are probably going to agree that. And you're going to have to take a view at that point on whether it's in the children's interest, first of all, and secondly, whether the court is going to entertain you in being able to pursue allegations, which you don't need because threshold has been met on the basis of the concessions given. And really, your focus can then switch to what is needed on the welfare stage. On the more difficult cases, where as the case has been progressing, you've got more and more evidence that's come in, you've got serious allegations perhaps about violence towards the children or sexual abuse or non-accidental injuries, you've got police evidence, you've got medical evidence. And really at this point you're thinking, what is it that I can prove? What can't I prove? And the parents are resisting all the big stuff. And that's when I think it's really helpful to, if you're going to instruct counsel to deal with a contested final hearing, to get them in at that point, because they can really shape the way the case has gone. They can really go through and do a complete check really of the evidence against the threshold, against your threshold criteria and the findings you're seeking, and spot then what's missing and what evidence you don't need. It usually doesn't make sense to wait till an IRH hearing or 5 minutes before the IRH hearing to draft up a final threshold when you've got serious allegations which you are seeking to prove against the parents who are resisting. And that should be dealt with as soon as you can, earlier on in the case, a good month or so before you get to the IRH stage. So I think at that point, it's if you're going to use counsel, get them in then. And then I want to say a few things about style, if I can. Nobody drafts thresholds in the same way. It is probably more of an art than a science, although James has very helpfully gone through what needs to be there legally. But I think it is very much an art. People will deal with things differently. Judges will take a different approach. Some judges just want enough on threshold to get it over the threshold. Other judges are very content to go meticulously through all the different allegations. And so you'll need to know your audience a bit there. And also you'll need to know what your opponents are like and what points they're going to be taking against your threshold as well, and adapt your threshold accordingly. Threshold captures the reasons why the local authority is saying the court has jurisdiction at the relevant date, time you're bringing proceedings. And it's often the case you'll see a whole raft of allegations which are about the mother, often, because that's often the way it is. And the father isn't really mentioned in the threshold criteria because he's been a distant figure in the children's lives. And it's just when you get to a final hearing and the focus is all on what the mother has done wrong or hasn't done wrong, particularly in a neglect case, and there's nothing on the father, but the reality is because he hasn't done anything. And it's just one of the things you need to think about in a case like that, where you may have a father saying, well, I think the children can come and live with me. All your thresholds, all about the mother. Look how much he's neglected the children. I can do it. So you need to think about where his behaviour or his deficits might fit into your threshold, as well as the welfare state. Another thing you might want to think about is pleading allegations in the alternative. So often you'll get a child, sadly often, who makes allegations of sex abuse. Now, those things may or may not be true. They may or not be capable of being proven. But there is always going to be concern, even if they're not true, you can't prove them. Why would a child be making up such allegations against her parents? And is there something else going on that warrants the child making up such allegations so that they can go into care? So think about drafting things in the alternative, if you have to. And then I think the last thing I would say about drafting a threshold is you should look at the document as you would do if you were pleading any other case, and think about what would my opponent do to try and destroy this? Where would they find the holes? Where would they say there's no evidence here? Where would they say you've lost focus, or it's too historic, or yeah, that happened, but it's not really harm, or it didn't really affect. Yeah, there was a fight in the street, but it was nowhere near the children. Have they been harmed? And try and knock your case out one by one. So put on your opponent's glasses and have a good look through your threshold document and see whether you've left some difficulties for yourself. You can perhaps tidy up before you send it off to the judge. So that's what I wanted to say about drafting. I think that was the last slide. Oh yes, the last slide says, any questions?
Any questions? And just to sort of conclude that thing before we get on to questions, I mean, the reality is we've all seen it. Everyone always complains about threshold documents. I'm sure everyone will continue to complain about threshold documents. But I think if you focus in on the case of Rie and you really demonstrate these are the facts, that's the harm, that's the abuse, and you make that connection, and so long as you cross-reference with the evidence, you should be in a much better position. And the other crucial thing which Helen said, which I'm going to emphasise again, don't leave threshold to the end. So many people do, and you come to an IRH or an early final hearing and you want to conclude matters, but no one's thought about threshold. Get it sorted out as early as possible, because as I said right at the outset of this webinar, threshold should be capable in most cases of some sort of agreement quite early on. That's not in every case, of course, I accept that absolutely, but in a vast majority of cases, you're in proceedings. There must be a reason why you're in proceedings. Why are you in proceedings? That's your threshold document. Okay, so do you have any questions?
We haven't, which means either we've just covered everything so comprehensively, or that people need a bit of time to think about that. I don't know whether a better way of dealing with that is if people have questions, they can perhaps be emailed through and we can respond by email.
Yeah.
If that's going to be more helpful. It's not quite the longest day of the year, but it's for some hours. So we can deal with it that way. And then the other thing is a question we've got for you, in fact, which is sometimes when you're drafting threshold, it's such a practical job, whether people would find it helpful to have a hands-on workshop on drafting, which would be not by webinar. It'd be old-fashioned, sitting in a room and going through some examples together and thinking about how to draft things. So that's something we can organise if people are interested. So I'm just checking my email. Yes, good question coming in. Do you have a good anonymised threshold linking allegations of harm that you could share? Good way of wording it. So yes, requests for example threshold documents. I think we could probably put a few together and send them round to people who've attended. I think that's probably what we should do, James.
Yeah, sure.
Yeah.
Okay. Well, thank you very much for everyone for attending. As has just been said, any unanswered questions or if there are any questions, even those can be followed up by email. To reiterate, this has been recorded. It will be going up on the YouTube channel and our website. And finally, keep your eyes peeled for the next autumn/winter webinar series that will be coming obviously later this year. Details will be released in the next few weeks. So great. Thank you very much, everybody.
Thank you.
Bye-bye.